All rise. The Honorable Justices of the Supreme Court. All rise. Hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court, now sitting. The Honorable Justices
Please be
of the
seated.
Supreme Court. All rise. Hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court, now sitting. The Honorable Justices
Please be
of the
seated.
Supreme Court.
Maybe watching on our,
All rise, hear ye, hear ye.
Those
All
who may be
persons having
watching
business
welcome
before
to
this
Kansas
court
City.
are admonished to draw nigh and give their attention to the court, now sitting. The Honorable Justices
Please be
of the
seated.
Supreme Court.
maybe watching on our,
All rise, hear ye, hear ye.
Those
All
who may be
persons having
watching
business
welcome
before
to
this
Kansas
court
City.
are admonished to draw nigh and give their attention.
The court has read those briefs and is familiar with them. We've also looked at portions of the record that occurred at the trial court level and reviewed those portions that are relevant to the issues that are before us today. So we do have notes. We do have those documents even on our computers or printed out in front of us. And so sometimes we will be looking at those documents and our own notes. We're not, please be assured that when we do that, we are still listening attentively to the arguments, but sometimes just checking something to help us assimilate the council's arguments. With that, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
First case on the 9 a.m. docket for Wednesday, December 13th, 2023 is appeal number 124510, State of Kansas versus Derry Jean Green, Wyandotte County. Briefs both sides.
May it please the court, James Ladd of the Appellate Defender's Office representing Derry Green. I'm ready for argument, and Chief Justice, may I please request 3 minutes for rebuttal?
3 minutes is granted.
Thank you.
May it please the court, the appellee of the state of Kansas appears by Deputy District Attorney Kayla Rayler, present and ready for argument.
Second case is appeal number 124303, State of Kansas versus John R. Cantu, Reno County. Briefs both sides.
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of John Cantu, and I'm ready for argument.
May it please the court, Kimberly Rodabaugh appears for the appellee in the state of Kansas. I'm a senior assistant district attorney in Reno County, Kansas, and I'm present and ready for argument as well.
Your Honor, that concludes our 9 a.m. docket.
I would ask counsel in 124510 to come forward. Whenever you are settled and ready, you may approach the lectern.
May it please the court. Again, I'm James Ladd of the Appellate Defender's Office representing Derry Green. And as your honors will recall, this case is a premeditated murder coming straight to this court. This case revolves around a shooting incident at a liquor store where an eyewitness claimed that my client shot the victim. And for my arguments today, I'm going to focus on issue 2, unless, of course, this court has any questions. And I'll probably keep my remarks brief unless this court has any questions on it, which I'm sure once I start talking, this court will have something to say about that. But for issue 2, I'm arguing that premeditated murder is unconstitutionally vague in regard to second-degree murder. And my argument is that there's no objective standard differentiating premeditation between an intentional act. So my whole argument basically comes down to the primary problem, as stated in this court's case in Harris, is that when there's no objective standard, it invites arbitrary enforcement. And because premeditation, because any prosecutor can allege premeditation, because as this court itself has said, circumstantial evidence usually causes is usually the evidence used to prove premeditation. That in any act in which there's an intentional murder, the prosecutor, for any reason, without an objective standard, can charge first-degree murder. And for that reason.
How does our Stanley decision not resolve this case? I mean, doesn't your argument essentially require us to overturn Stanley?
I don't think this court needs to overturn Stanley. This court could just invalidate first-degree murder. What my argument with Stanley is that even with Stanley, where this court said that we have, now we know for sure that premeditation requires time and reflection. And so my argument is that because the primary evil we're looking at is arbitrary enforcement, that standard is actually not an objective standard, because a prosecutor can still allege in any intentional murder, a prosecutor can allege facts that there was premeditation.
How does that make it not objective?
Because we still have arbitrary enforcement. That, by definition, the Harris case says the primary evil we're looking at is arbitrary enforcement. And so my argument is that as long as we can still have arbitrary enforcement, then by definition, it's not an objective standard. That's my
That's
argument.
just a circular argument, isn't it? You say it's not objective, so we get arbitrary enforcement, and we have arbitrary enforcement, so it's not objective. I don't think that helps us any.
Sure. But that's the way it goes, and that's still the primary evil. I mean, I don't know how we can say that everything's okay when in any case we can still allege.
Well, without mentioning arbitrariness, can you articulate why the standard, the legal standard for premeditation is not?
Because we have nothing differentiating. In real life, where we have circumstantial evidence, there is not, in any case, we can claim premeditation, just because as a matter of fact.
What can be claimed has nothing to do with what the legal standard is, does it? If the legal standard is what you just described from Stanley and other cases, a period of time, there's a temporal aspect and a mental aspect, a thinking it over beforehand. I mean, I'm just looking I'm giving you the opportunity to make your best argument as to why that's not objective.
Sure, and my best argument is, all I have for that argument is that because it still can allege premeditation in any act, there can still be arbitrariness. There's no objective standard in every case. That's my argument for that one.
How would you define premeditation then in a constitutional manner, at least under your argument and theory?
Sure. I don't have a definition for premeditation. I would say that's part of my argument, is that we have to have the legislature define it. And they have to, I mean, we know from the fact alone that they enacted second-degree murder and first-degree murder that they wanted a difference. And I think they need to give teeth to premeditation, where we have a real difference when we have such big disparities in punishment. I mean, this case, for example, I'll say, Derry Green was charged first with second-degree murder. The state had basically all the facts in the affidavit, the same facts that came out of the preliminary hearing. And then they changed it to first-degree murder. So, I mean, I would say that supports that just in any case, you can charge any intentional murder, you can charge first-degree murder. And unless there's any other questions on any other issues, I'll stand on my briefs.
Thank you.
Thank you.
May it please the court, the state of Kansas appears by Deputy District Attorney Kayla Rayler. I will focus my arguments on premeditation. There is an objective standard for premeditation as defined by the statute, and that is that an individual has to have the opportunity to reflect upon the thing they are about to do.
Could you give me, let's just start where council left off. Can you give me an example of an intentional murder that isn't premeditated?
Yes, an intentional murder that is not premeditated is one where the individual committing the act had no opportunity to reflect. It is an individual that forms the desire and the intent to kill at the same time that they are committing the murder. For example,
Instantaneous, that's the difference.
that is the difference, Your Honor, and other jurisdictions have found that distinction with their own definition of premeditation. In Tennessee, they actually had their premeditation definition challenged on appeal in 2000, and they found that while first-degree murder requires forethought, second-degree murder only requires a simultaneous awareness of the conduct or result. And that is exactly how we define premeditation. The act has to be reflected of at some moment in time before they do it. It cannot be at the same time. So if somebody is in an argument and doesn't reflect upon what they're about to do and just pulls out a firearm that has a Glock switch on it and starts firing automatically without thinking about what they're about to do, that would be second-degree murder. That would not be premeditated murder because it doesn't have any of the factors that this court has laid out to help establish what premeditation means. Going to the definition of premeditation, though, go back to our canons of construction. We give ordinary words their ordinary meaning. And the Merriam-Webster Dictionary defines premeditation as consideration or planning of an act beforehand to show intent to commit that act. And that is exactly how this court has defined premeditation, is that there has to be some instance of reflection, no matter how small, before they commit the act.
I think our Stanley case, well, I know our Stanley case talks about this exact question in terms of intentional acts that are impulse decisions, as opposed to intentional acts that are reflected upon.
Correct.
That essentially your argument.
That
Are
is
you
essentially-
agreeing with that essentially?
Yes, Justice. I believe that Stanley provides this court with the exact guidance that it needs to make this decision, in that premeditated first-degree murder is constitutional and has been the law of the land in the state of Kansas for over 20 years. There is no reason for this court to depart from our precedent unless there is a good reason to be departing from it when it has been so well established over the course of 20 years. And right now, premeditation is defined by common sense. It is defined by this court. It is defined across several states as just having the opportunity to reflect upon what somebody does, no matter how short. Tennessee defines it that way. Florida defines it that way. Minnesota defines it that way. Arizona defines it that way. Indiana, Iowa, Missouri, Nebraska, North Carolina, Rhode Island, South Dakota, and Washington State all define premeditation in a way that is very similar to ours. And the only constitutional challenge that I could find in preparing for today's argument was the state of Tennessee that went through an analysis that the difference between premeditation and second-degree murder is exactly what was brought before today, that it cannot be a simultaneous act. There has to be some period of reflection.
Again, I'm just trying to imagine, isn't pulling a trigger takes some, it's not a simultaneous, you have to think, I mean, even if it's reflexive, you're still engaging in some brain cognitive thinking about doing it, even if it's quickly. It's a very tough, it's hard to get over that hurdle of what is reflective and takes thought, and what is versus what is reflection.
Yes, it is difficult, and that's why we leave that ultimate fact to a jury to decide if the state has met that burden of, that time period to reflect upon the action that occurs. But also, it comes also down to that individual person's experiences in life. An individual who grows up in a neighborhood where there's a lot of violence would probably act more impulsively or irrationally than an individual that grew up in a more well-to-do neighborhood that doesn't have a lot of crime or violence. Our social backgrounds and upbringings bring us to different experiences in life and give us different reactions to different stimuli that we may experience. So an individual that may have grown up in a high crime rate neighborhood who hears a lot of gunshots may be more reactive to the sound or more reactive to pulling a firearm without even thinking about it, because that is their nature and an environment that they grew up in, versus an individual that grew up in a lower crime rate neighborhood who doesn't have those experiences that a higher crime area might have. For example, taking just a broader approach to it, we all go out to lunch somewhere and we walk into the restaurant and we see a big line. And before we even realize it, we have turned and walked out the door because we don't want to wait in line, but we didn't even make that decision. We weren't even aware we made that decision. We just walked out the door because of what we saw. That is the difference between an intentional, between premeditation and a reflective action. You didn't think about leaving that restaurant. You just walked out seeing how long the line was. It's an impulse. It's a visceral reaction to something versus I'm going to chance it and I'm going to sit here and I think I can make it back to work in time in my time limit versus just walking out the door. I would stand on the rest of my brief if there are no additional questions.
Thank you, counsel.
Our Mark's brief, in all those examples, you could still at least allege. I mean, when someone walks in a restaurant, the prosecutor still alleged they thought about it before they walked out. That's really my argument. And then the only other thing I'll say is all the states that she cited, they're all wrong. In any premeditation murder, you can still, in any intentional murder, you can still charge premeditation. And unless there's any other questions, that's my argument.
Thank you.
Thank you, Your Honor.
Thank you to both counsel for your arguments this morning. The court will take this case under advisement. Again, for those watching on our live stream, what that means is that later today, the court will conference this case and other cases, and a justice will be assigned to take the primary lead in writing a decision of the court. All the justices will weigh in on that draft, and conversations will continue until the court reaches a final decision that will be filed with the clerk of the appellate court. And at that time, a press release will announce the publication of the decision, and it will be put on our kscourts.org website where anyone can read that decision. Thank you, counsel. We'll now call 124303, State of Kansas versus John R. Cantu.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of John Cantu. I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Your Honor, I would remind the court, this is a case out of Reno County. My client was originally charged with 2 counts of stalking, 2 counts of violation of a protection from stalking order, criminal damage to property, criminal trespass, and criminal threat. The Court of Appeals in this case set aside the stalking-related convictions. I'm sorry, the jury, first of all, acquitted my client of criminal trespass. The Court of Appeals in this case set aside the stalking-related convictions. So we're left in this case with a criminal threat conviction and a criminal damage to property thing. And the substantive claim at the Court of Appeals was that the that the district court in this case violated Mr. Cantu's right to testify on his own behalf in his own criminal trial by sort of too quickly striking his testimony. And the Court of Appeals agreed that that was a violation of Mr. Cantu's right to testify on his own behalf. And that was not cross petition, so that's final. Yeah, so, but the question before this court is whether that kind of error can be harmless, and if it can be harmless, whether it was harmless in this case.
Let's get back to error first. How many pitches does the defendant get to obstruct before error occurs?
So I just want to be really clear, first of all, that's not before this court, because the Court of Appeals decided it was error, and my colleague did not cross petition. So I do not believe that's before this court. That being said, the argument below was that my client expressed on cross-examination confusion with the question and was trying to get clarification, and the district court in this case cut him off and made him sit down and then struck his testimony. And the Court of Appeals, we think correctly viewed that that before you take such drastic step as denying a person their right to testify, that you should, first of all, be more patient, and secondly, give some warnings to a client, and third, if you're going to do that, you have to make some findings, and the district court did none of that in this case.
How many warnings do you have to give?
Enough so that we are confident that the client understands the consequences of its actions. Again, that's all decided by the Court of Appeals and not before this court. The only question before this court is whether the error in this case can be harmless and whether it was harmless in this case. On the first part of that question, as the Court of Appeals acknowledged in its decision, there's a split of authority among different jurisdictions. And interestingly, sort of from an academic standpoint or whatever you want to call it, as you look even within those cases, a lot of times there's disagreement among the jurists on the different courts that are deciding this question. And it seems to me as I sort of synthesized these and went through them, it depends on this question. The question that you're going to have to answer is whether or not the right to testify on your own behalf in your own criminal trial is just another kind of evidence. Because this court has found and other courts have found that, defendants have a fundamental right to put on evidence in their behalf. And this court and other courts and the United States Supreme Court has found that denial of the ability to put on some evidence can be subject to harmless error analysis, just like other constitutional errors. And so courts and jurists, I think, that find that it can be harmless are tending to say it's just another piece of evidence. Just everybody gets to put on evidence on their behalf. Some people, if they're denied that wrongly, that's subject to harmless error. Courts and jurists that find that it's not subject to harmless error are saying it's something different. That the ability to stand up and testify on your own behalf in your own criminal case, the act of doing that is something different. And because of its importance, because of the fundamental nature of that, by stripping somebody of that right in their own criminal trial, you can no longer say that that trial is an opportunity, a meaningful opportunity under the Due Process Clause to defend yourself.
Counsel,
About
do
the
you,
right to be present.
that was going to be my exact question.
Can you clarify what you mean in that regard, Your Honor? Your Honors?
Well, the right to be present, we know, is a conditional right, subject to harmless error.
This court has found it's subject to harmless error if the denial of the right to be present doesn't affect the fundamental nature of the trial. And so this court, for example, in Calderon said it's not subject to harmless error if a person is meaningfully denied their right to be present for example, closing argument.
Right, which that basically means it's not structural error.
But it
Not going to
depends,
automatically reverse.
but it can be, the right to be present can be in the circumstances, depending on the nature of it. You could say because of that, it's not subject to harmless error in those circumstances. It's going to depend on, for the right to be present, the nature of the denial of the right to be present.
Is it correct? Am I understanding you correctly that your argument is the right to be present is a much broader, casts a very broad scope? And
Yes.
certain instances are subject to harmless error, but there are certain kinds of not present that fall under structural error, and this is one of them. That is what I understand.
My argument is that the right to testify on your own behalf in your own criminal trial certainly has an evidentiary aspect, and part of it flows out of the compulsory process clause. That's true. But it is my argument that the right to testify on your own behalf in your own case is much broader than that it envisions a much more important value, and that's the autonomy of the defendant in this case.
Not just that he was removed from the courtroom for being disruptive, so he wasn't present.
But don't the cases from other jurisdictions seem to draw a line about situations where it is nothing to do with the defendant's action that results in the loss of that autonomy? In other words, some of those cases, it is that counsel didn't talk to the defendant about the right to testify and just announced to the court that the defendant wasn't going to testify. Or, some situations like that, as opposed to this, where the defendant knew of his right, the defendant was on the stand, and it was by his actions that that resulted in the court taking some of taking the steps. So it's a little different factually in terms of he had the personal autonomy to respond to the judge in a different way, a less confrontational way.
So, I mean, I'm just trying to parse out the question. It can be different, and by the way, I wanted to caution the court, as you look at the different cases that talk about harmless error as it relates to the right to testify in your own trial, some of the cases, and in fact, some of the cases cited by this court in Carr are really more like ineffective assistance of counsel cases or things like that, where the attorney's advice, or maybe stronger than that, interfered with the right to testify. That's a different circumstance than we're talking about here. Here, the district court absolutely denied it's not what the attorney did in this case. The attorney in this case advised my client not to testify. He decided over the attorney's objection to testify. The district court in this case is the actor who interfered with the client's right to testify. And again, it feels like you're going back to Justice Biles' questions, like, is this really error in the first place? And that's already decided. And the answer is yes.
No, I think it goes to the constitutional what standard we apply as we assess it. It seems to me that there's a difference that perhaps that the constitutional right is the right to exercise your personal autonomy to make the decision to testify. I don't know that it gives you a constitutional right to be disruptive if the judge feels you're being disruptive.
No, that's not my argument. I mean, I'm acknowledging, and we do acknowledge that probably, it hasn't been held, but it's rational, just like the right to be present, that you can lose your right. You can lose all sorts of rights.
And I think that the harmlessness standard may be different under those two situations. That if you are in a situation where the person is testifying, and through that person's actions has had the ability to provide some testimony, but then crosses that line, are we then looking at a harmlessness situation? That is not a constitutional, not the same high burden as having lost the autonomy to make the decision.
Is your question if there's not a complete denial of the right to testify, but more like a partial, like certain questions or some line of questioning was cut off, and we would say later, well, that was improper?
There's some testimony.
Got some testimony in,
So then
and are
are we
those
back to
different?
weighing, like you would in many other trial errors, what the level of harm was?
It's still, I think well, certainly it's not the case before this court, because there was a complete denial of his right to testify
Well,
in this case.
Well, that's a question I want to ask. So I don't want to interrupt this chain though, but I'll go back to that in a minute.
Yeah, I mean, whether there's some sort of like analysis of whether a particular denial is de minimis. And I think that's sort of the approach that this court has taken with the right to be present, right? That there are certain kinds of, or de minimis, maybe violations of the right to be present that aren't so serious that you apply structural error. But then there are some that are, like denial of the right to be present for your entire closing argument. This court has said we don't need to go to whether that's going to affect the outcome of the trial because you have so badly infected the trial itself. When you
Right,
do
but that goes to my point, which I think, really, in State v. McDaniel, really got to the core of it. When we're differentiating between structural and harmless error, it's the nature of the error, not the nature of the right. Not, you're pointing that out right there. It's not the right to be present. It's the nature of the error. And you evaluate the nature of the error and you say, well, does that implicate the fundamental fairness of the trial mechanism itself? And whether that error is quantifiable and determinable. And so the importance of the right is not the touchstone, and not only our court, but SCOTUS says the ability to discern the effects of the deprivation is the most important factor. Does the effect of the deprivation implicate the fundamental fairness of the entire trial mechanism? And is the error quantifiable and determinable, right? Would you agree with that?
Your Honor, I see I'm out of time. I haven't even got to talk about whether it is harmless if it's possible. So
I
can
wanna
I,
hear about that.
can I answer the Justice's question? So, so there's actually three parts. And so I think you've identified one of them, which is whether it goes to that, whether the trial is sort of fundamentally unfair. But there are also two other ways. So yes, I agree with you as far as you look at the nature of the error. But one of the parts of there are two parts of it that are in favor or that are persuasive as to why it should be structural error in this case, for this kind of error. And so the United States Supreme Court has looked at some things that have talked about whether, like right to public trial, and whether that goes to the fundamental fairness of the case. But there are other things like the right to self-representation that aren't quantifiable. And there are other errors that are not about the outcome of the case, but go to the fundamental thing of like whether or not the defendant gets to drive the conduct of the case. And that has nothing to do with the outcome of the case.
Right, but isn't here the fact that we have his testimony? We have his direct testimony. So we know what was taken away. Why isn't that determinable and quantifiable?
Because, okay, I think it's possible that it could be, but it begs the question of what about some other case? And in fact, just like the right to self-representation, one of the primary reasons the right to self-representation or denial of the right to self-representation isn't subject to harmless error is because it wouldn't make sense, because almost all of the time, it's good for a defendant to not be able to represent themselves. That's what we all think as lawyers, that you're better off with a lawyer than not. And so it wouldn't make sense. And in fact, the same kind of thing is true, at least in a lot of cases where a defendant wants to represent themselves. I remember a case, Your Honor, this is a long time ago, and it's not the details that are important, but I remember talking to the lawyer, the trial lawyer, which we don't do very often, but I did in this particular case. And the trial lawyer said, you know, the funny thing about this case, I talked to the jury afterwards. They were 11-1 for acquittal until my client testified. It was a bad idea for him to testify. And so in a particular case, you're right, Your Honor. In this case, it's unusual that we do have the testimony. But if you're applying that and saying, you know, but we can justify this, but the denial, if that client that I just talked about had been denied the right to testify, that denial would have been just as complete, and the deprivation of his rights would have been just as complete.
Right, but the
regardless of
error would have
outcome.
been different. So that's what we're saying is. So, you look at not the right, but the error. And so just like in our right to be present cases, where sometimes we say it's structural and sometimes it's constitutional, in this case, you see what I'm saying? That we don't have to have a rule that, the right to testify is never, ever structural error. But if the defendant says, I want to testify, and the judge says, I'm not going to allow you to testify because I don't want to hear from you, not because of conduct, not because of anything. Well, then if that came up, maybe that is structural error.
It is structural error. But I guess I'm still not,
But we're looking
Following
at
on
the
the-
nature of the error here as, you know, I mean, as the Supreme Court and our court has, you know, State versus McDaniel, we're looking at the nature of the error here.
but I guess I'm having a hard time separating out, Your Honor, like the nature of the right and the nature of the error are different things.
Right, the nature of the right, it's not, I mean, the nature of the right is not the touchstone here.
Well, I guess I disagree under Fulminante and Weaver in those cases.
Can you get to, yeah, you were gonna mention getting to harmless. And the Court of Appeals found that it was, harmless error, and I think that's before us also. Was there any other evidence besides his stricken testimony that said your client wasn't there?
No,
I didn't understand he pled not guilty. Now,
Yeah.
that didn't make sense to me.
Yeah.
But other than that, there was no other evidence that was presented before the jury that suggested he wasn't there besides that stricken test.
no.
Is that
and-
right? Okay.
And
I
when
want-
we look at the test, and the Court of Appeals cited the test, I mean, if you're going to do a harmless error analysis in a case like this, you look at how important is the testimony to the defense. It's extremely important in this case because it's the only testimony that explains his presence in the area, right? Because these events happened and the complaining witness called the police and the police found my client not too far distant. And so he has to explain, what are you even doing around this area? And his testimony does that exactly. The second part of it is it non-cumulative? If it's cumulative to other testimony or evidence, then that could certainly weigh in favor of harmlessness. So for example, if they had gotten a statement from my defendant, police had maybe gotten a statement from my defendant, and the content of it was exactly what my client testified to, right? Then maybe in a situation like that, I could see where you get closer to that. That's not this case at all.
This is the question I wanted to circle back to, and it's in part a record question. The judge said, "I strike," but was there ever an admonition to the jury about what that meant, that they should disregard that? Or any explanation by anyone, really what that meant to jury?
Yeah, and I found this really a difficult part of the Court of Appeals decision, respectfully, that suggests that, well, so the answer to your question is, there was no specific admonition after the testimony was stricken. The judge didn't say, and jury, you cannot consider this evidence now. On the other hand, the judge did, as every judge does, I bet, in every case, in the preliminary instructions, volume, well, I don't have the page numbers. Well, no, it's volume 6, page 54. In the preliminary instructions says, I decide what evidence you should hear and what evidence you shouldn't hear. During the course of the trial, you may hear objections by one of the attorneys to certain evidence being offered. You should consider only testimony and exhibits admitted into evidence. When the discussion happened between the prosecutor and the judge here, the judge that my colleague asked, I would ask for everything he testified to be stricken from the record. This is page 169. And the court says, I believe the state's request is valid. His testimony is instruction. Instruction number 1, the jury instruction given to the jury, says, this is record 1, page 88, you must disregard any testimony or exhibit which I did not admit into evidence. And so the answer to your question, Your Honor, is no, there wasn't a specific admonition about that. But as is the case in every case, the jury was instructed in this case that you cannot consider evidence that I don't admit into trial. And the jury heard the judge say that evidence is stricken. And so I think that's a remarkable precedent if you find that that is not, that you don't expect the jury to follow that instruction. I know we live in this legal fiction world sometimes, right? Where we have instructions and we tell juries things and we were like, are they really going to do that? But we do live in that legal fiction world. And the judge in this case, instruction number 1 was, you cannot consider evidence I did not admit into trial. And the judge said that testimony is stricken. I feel like that makes it pretty clear that we have to assume the jury followed its instructions, unless you're willing to say you don't think instruction 1 meant anything. Thank you, Your Honor.
For Kimberly Rodaba, I appears for the appellee, state of Kansas, and I'm the senior assistant district attorney who tried this case out of Reno County. I think the beautiful thing about what we do is you always reflect what you could have done better. And quite frankly, in this case, when I look at when the defendant took the stand, my instinct was, well, it doesn't make sense for him to be able to testify without the state being able to cross-examine. And so my knee-jerk response was to ask for the statements to be stricken. I differ, though, as to whether the statements truly were stricken. I appreciate Mr. Hodgkinson's argument that one of the arguments or the instructions that the court gave was you're not to consider evidence. But if you look at the fact that there was no admonishment, there was reference to that theory during closing argument, and that was the theory of the defendant. It does tie back to the fact that in this particular case, it should be judged on a harmless error standard. And I think one thing that we haven't focused on is this was not an isolated incident of Mr. Cantu.
Okay, I want to.
Thank you,
just
yes.
Interrupt very
Please,
quickly.
I
um,
would,
'cause
yes,
we have a lot of stuff here.
yes.
So first of all, your opposing counsel said at the beginning, which made sense to me, that the Court of Appeals made its ruling that there was error. And that is not something that you filed a cross petition on. So do we all agree that, you know, the error is not before us, and the only two things that are before us is, can it be harmless error? In other words, is it structural error or harmless error? And then if we say it can be analyzed under harmless error, was it harmless? Those are the two issues before us. Is that right?
I agree that we did not cross petition, but I think considering the totality of circumstances also goes to the harmless error argument. So,
Right, but in order to analyze it under our constitutional harmless error standard, we're assuming there's error, correct?
the state did not cross petition.
Okay, so you would agree that we have to assume there's error, right?
Since the state did not cross petition.
Okay. And then, so your argument about that you have to consider the totality of the circumstances, that goes to whether or not there was error, correct?
Yes.
So that would not be relevant, right?
I hear what you're saying. So thinking about that, it's relevant in analyzing the harmless error or not.
How?
Because what we focused on is an isolated incident where Mr. Cantu took the stand and he testified a short amount, but he'd been playing games during the trial the entire
But
time.
how does that, harmlessness goes to whether or not we are convinced beyond a reasonable doubt that the outcome of the trial would have been different, right? So that's what we're looking at in harmless error. So how would it matter to the outcome of the trial, whether or not you're looking, whether, she took him off the stand because of the one instance or because it was a buildup?
Could you rephrase that? Or I'm not understanding your question.
Okay, so in analyzing harmless error,
Yes.
the standard is whether it would be reversible error if we found beyond a reasonable doubt that the error did not affect the outcome of the trial.
I think we're also, though, looking at the district court judge's actions in that particular case and analyzing the harmless error. And I think that's important to, when I said I reflect on things that could have been differently, I tried to figure out how could I make a record that this was during COVID and the defendant kept messing with his mask or sniffing the hand sanitizer on the table, or that he was slumped down his seats and the deputies had to put him back up. And so when
I'm not really following what you're saying, how that goes to harmless error, but let's assume that you would like us to look at the whole record. Given everything that happened up to the point that he went up to testify, correct?
yes,
She allowed him to testify, right?
she did. And I liked your point that we do see his testimony. He
Right,
basically
but
said,
what I'm saying is that none of that stuff, I mean, she, when you look at what she said, she said that the record shows the court removed him. Okay, we don't look at the circumstances before he was removed from the stand. The fact that he was permitted to testify necessarily means that the court had not made a forfeiture finding based on the earlier conduct, right?
and the state did, when I qualified, and I think you heard in my language, the state did not cross petition. That was a mistake in the state not cross petitioning because
But the court did not make a forfeiture finding based on the earlier conduct, correct?
in my reading of the case, I agree with that,
Okay.
yes.
And the record shows that the court removed him from the stand and then implicitly held he forfeited the right to testify because he didn't wait for the next question before talking, correct?
What happened during the court was he kept being, it's fascinating because I was looking at this morning, and Illinois versus Allen says, Mr. Hodgkinson says that someone has a right to testify, but the state contends it's not absolute right. And in Illinois versus Allen, 397 US 337, it says, we believe trial judges confronted with disruptive, contumacious, stubbornly defiant defendants must be also given discretion to meet the circumstances.
I'm
of
not
each
talking
case.
about what the law is. I'm just asking you. The reason she held he forfeited his right to testify was because he didn't wait for the next question. Basically, he wanted to go beyond the yes or no answer on cross to explain his answer. You were at the trial. Is that true?
We're getting inside the trial court's head, but I think it was what happened during voir dire when he
No,
was
I'm
making
just-
gestures.
right, but like I said, she didn't. Never mind.
She didn't articulate it on the record.
That's fine.
Okay.
Go ahead.
Counsel, my question is, so we have the circumstance where a defendant is erroneously disallowed from testifying on his or her own behalf. I want to just sort of zoom out to a very, I guess I would say, sort of common sense, in a common understanding, almost Perry Mason sense. How was this a real trial? It strikes me as so fundamental to our notion of a trial that you have both sides presented, that I am struggling to see how this is even a real trial.
But a real trial should have rules of evidence. And so as
I'm
far
not
as,
talking about error. I'm saying I'm starting my question from the premise that a defendant is wrongfully restricted from testifying.
but the state doesn't agree that he was wrongfully restricted from
But we're
testifying.
stuck with that, and I think you just admitted that that's your answers to Justice Standridge, that that's the posture of this case before us.
Okay. So if he was wrongfully restricted from testifying, it still is harmless error, because if you look at what he said,
So I'm asking, how is it even a real trial? Just in a very fundamental sense. I mean, another way to say it is, how is this not, I mean, I know it's a very pejorative term, but how is this not essentially a kangaroo court? Where the state just comes in and they're the only voice, and
The state
It's
can.
not a real trial.
Well, a real trial also has rules and proper decorum to the court, and, and all parties, including the defendant, have to abide by those rules. And
So you're just circling back to, we really should just take into account that this is not error.
yes, and the reason, the state not only stands on the written brief, but the reasons it was not error, the state adopts the arguments from the Court of Appeals that it wasn't error, is because the testimony had, we know what the testimony was, and the beyond a reasonable doubt, it wouldn't have changed the verdict. And so it still is not a minuscule analysis that goes into it, but even had, and the state contends it really did stay because there wasn't an admonishment, they still argued it wasn't him, et cetera. But even with that, there was such evidence that was compelling as far as what the mother had said she saw, what the children had seen, what the brother had seen, the physical evidence of the block being thrown through the window. They had him on camera, recognized his voice, and even if he said he was not there, there was enough substantiation with independent witnesses and with law enforcement that applying the harmless error standard, it wouldn't have made a difference.
Let me see if I can get it. What the colleagues have been asking. If Judge Rose had not allowed him to get on the stand at all, had the ruling been, you annoyed me early on during voir dire, and I'm going to take away your right to get up on that stand and testify, okay? Error. Isn't that structural error?
If it would be arbitrary and yes, I think there'd be more of a concern with that, which is not what happened.
Well, it's a mistake. I mean, we can all agree the judge should not ever deny outright the defendant's right to get up on the stand.
Agree.
You know, and so if the defendant doesn't get to testify, wouldn't we all agree that's structural error? We don't have to figure out whether the guy would have said something that might have made the difference to the outcome. We just know he has a right to testify, and he didn't get to do it.
I don't agree. He did get to do it.
Well, in my hypothetical, he
Okay, I apologize.
didn't get to
Yes.
even get on the stand. Okay. So in your case, he gets on the stand, and then the court erroneously, because we're stuck with that, erroneously strikes his testimony. What's the difference in that, in your case, where the testimony was stricken and not allowing the defendant to even walk up to the stand in the first place?
The state contends, in essence, his testimony wasn't stricken. He still got to argue it. The jury was not admonished. The state wasn't able to cross-examine.
Are you saying, I mean, this is the argument that counsel's making, those jury instructions tell the jury not to consider things that the court didn't allow into evidence. That's how we keep them from getting on the internet and just deciding that there's other facts or going to the scene without court approval. I mean, that's a pretty important instruction, and that instruction told them not to consider evidence that wasn't admitted. And that evidence was stricken right in front of them. Well, how isn't that the same thing? And that's what I think everybody's struggling with here. Why isn't that the same thing as just telling the defendant, you don't get to get up there and talk at all.
I think that in order for it to be stricken, there really wasn't an explanation what that meant. And so I'm not certain it truly was stricken.
Words, the jury may not have understood what attorneys and the judge understand strike mean. to
Yes.
me. Is that your argument?
This is part of my argument, yes. And if there are no more questions, then I stand on the rest of the brief.
Your Honor, my only point in rebuttal, it goes to, if you were considering harmless error, it's sort of interesting to think about, even if you would say it's not always harmless error, is this the type of error that would almost always be harmless error, given the nature of it? And I know that this court you've all been involved in trials in different capacities. And, we see, even during jury selection all the time, it's a question you ask jurors, is it going to bother you if the defendant doesn't testify? And it's the thing we have to talk about. We have to give jurors instructions that you can't consider the fact that he didn't testify, but they can consider that he did testify. That can be. And in fact, we have every reason to expect that that's important evidence. And I don't have to prove that they would even believe my client. That's not the test. The test is there any reasonable possibility that one or more jurors would have formed a reasonable doubt? I think it's an extreme set of circumstances if you find, I don't believe there is such, but if there is, that's an extreme set of circumstances, and it's not this case. This is not overwhelming evidence. This was not cumulative evidence. Do not believe you could find it harmless beyond a reasonable doubt.
The trouble I had was, defendant gets on the stand, testifies on direct examination, and then completely obstructs the cross-examination. Basically, we're going your way, we're putting the trial court in the position, make darn sure they're not wrong. Intercede to try to make sure the state gets its right to present evidence, which may require, after whatever the right number of warnings is, that jury be told that the state didn't get a fair shot and you're to disregard the testimony of the defendant. That's really what we're talking about here, is we cannot make that error. Because if we make the error, you're dead. You got a new trial.
Yeah, that's right.
So why doesn't that incentivize the defendant to just see how far they can push it and then claim later on appeal that they didn't push it far enough? Be wrong. How do we give trial judges any kind of guidance as to when enough is enough?
So my main response is when you talk about incentives, I think where you really need to be thinking about is, yeah, that's a serious move that you're going to make. Just like it's a serious move when you decide to remove somebody from the courtroom. And we acknowledge that judges need to have control over the courtroom, and we're not disputing that. But when you're making that decision, you do need to incentivize trial judges to understand that's a pretty serious decision you're making. And you better understand and make sure the defendant understands this. And particularly, I think this record even shows a defendant, and we see this not infrequently. Lots of defendants don't understand the process very well. They may have mental illness that interferes with their sort of ability to cope with the circumstances in a courtroom. And so and even the Court of Appeals acknowledge, and I acknowledge, it can be frustrating for a district judge. And we're not saying district judges can't control their courtroom. But it is appropriate to say, if you take this step, just like if you take an improper step with regard to self-representation or other things that really go to the heart of the autonomy of the defendant to be able to be in his own trial, trial judges should understand there's a consequence.
Chief, may I ask a question, even though his time's expired? I did have one question I didn't get to ask you before, and I know that, that you mentioned the Carr decision, the earlier Carr decision. I think it was 2014 or 16, in your brief. And so, but I think you distinguished it and said that it didn't really go to the right to testify. But when I read it, Carr challenged the exclusion of hearsay evidence, which is what you pointed out, but he argued he would have personally testified if the court had permitted that exculpatory evidence to be admitted under a valid hearsay exception. So he did say that he would have testified, and we found the excluded evidence was not only integral to his defense, but it, quote unquote, it was his defense. And despite basically the indispensable nature of the excluded testimony, which would have been his testimony, we evaluated it under a harmless error standard. But you don't, I mean, to me, that kind of sounds like we've indicated what our decision would be.
My understanding, and I'll obviously defer to justices and interpretation of your own decisions, but my understanding of it was the primary focus of the gravamen of that issue was the third-party evidence. That he was wanting to bring in third-party evidence like under Holmes v. South Carolina. And that was what was disallowed. It might be that there was other evidence too, but that the gravamen of that was about the third-party evidence. And you were using the cases where there's been a split of authority on this as persuasive authority that error could be found harmless. And I'm not disputing that. But it was not my reading of it that you were squarely deciding the issue of, in that case, did he try to testify and was denied the right to testify? And there are other cases, Your Honor, that talk about this sort of, you know, is it that he was given that choice, that catch-22? That's a different issue too. That's not our issue. This client wanted to testify. My client was absolutely denied the right to testify. That's before you, squarely before you, not on habeas, not as an ineffective assistance to counsel claim, but as a denial of the right to testify. Thank you for your indulgence with the time this morning now.
Thank you to both counsel for your arguments. The court will take this case under advisement. The court is now in recess until 10:30.